Appeals Division 1 is now in session.
Good afternoon. Please be seated. This is the time set for oral argument in State v. TEPPER. Our cause number is 1CA CR160294. Counsel, we have conferenced this case, read the briefs, and we're familiar with the issues, so you can bear that in mind as you begin your presentations. We are being audio and video recorded today, and those recordings will be made available online for you and the public. Each side has 20 minutes for oral argument, and the appellant is free to reserve as much time as you wish, subject to watching your own clock. So if you're prepared, we can begin.
My name is Nick Puchadlik, representing Mr. Alan Tepper, the appellant. And I'm coming to you with a case that is, in many ways, very easy, but at the same time is very challenging. This is an easy case because it raises only one legal question that answers itself. The question is it just to put a mentally ill, homeless old man in solitary confinement for over 2 years for throwing a rock through a window?
And if we answer that question in the negative, what's the remedy?
I can get there in 2 steps, and that's the first thing I do want to talk about. The first takes us back 120. The first step is this. We need to go back 125 years. In 1890, in In Re Medley, which is discussed in a case I cited, Madrid v. Gomez, the United States Supreme Court reviewed solitary confinement. And in 1890, it said that historically this has been a severe terror, a special punishment. It puts men into a semi-fatuous condition, makes them violently insane, drives them to suicide, and the ones that come through, their minds are so destroyed that they will not subsequently be of any service to the community. Well, fast forward, 1880s, we have the Seventh Circuit saying that there's plenty of psychological reports and data. We have, in the 90s, case I cited, civil rights cases for prisoners, observing that solitary confinement is like, for a mentally ill person, is like smothering an asthmatic. And then the 2000s, the cases I put into supplemental authorities, we have more civil rights litigation in prisons, and they call these federal courts from Wisconsin and Texas.
We're familiar with those.
I'm sorry?
Civil rights cases, we're familiar with those.
Yes.
But I think, and I don't want to rush you on this, but I thought the question was, what's the remedy in this case? Not if there was a civil rights action, what could the remedy be? So could I try to prompt you to get to what would be the remedy if we agreed with you in the context of this case?
Absolutely. It's dismissal with prejudice. And we can only understand that by looking to these civil rights cases and understanding that the conditions that Mr. Tepper was in are, in the words of those courts, devastating, causing a lasting psychological damage. That solitary confinement, this is out of Texas, is a virtual.
Isn't that something, though, that could be raised at some point during confinement? Wouldn't that be the appropriate time to raise a claim suggesting that the type of confinement my client is in is unconstitutional? It seems like an odd time to address it simply on appeal if it hasn't been raised to give people a chance to do something about it while the client is in custody.
Your Honor, people did try to do things about this. The defense attorney prompted 3 rounds of Rule 11.
But didn't that aggravate the situation? In all honesty, because after each round, and I understand I think I understand the reasoning for that, but it seems to me each round they said, okay, he's restored to competency, and then the defense counsel said, no, he's not. Send him back for more, and have an evidentiary hearing, and that sort of contributed to this problem, didn't it? I mean, because he's basically saying we want him confined more for a longer period of time to restore him. Wouldn't it have been better or perhaps more advisable to say either hold that he's restored to competency and let's get this over with, or hold that he's not he's not restorable, and dismiss the charges without prejudice earlier on, at least.
Your Honor, you just described Rule 11. That is Rule 11.
Right.
That was what the defense attorney asked for 3 times.
What did he ask for?
The defense attorney asked for the case to be dismissed or to be bumped into a track to address mental illness, which is contemplated by Rule 11.5, and that was at the 2 evidentiary hearings.
Where did at what point in the record did the defense counsel say, declare that he's not restorable so we can dismiss this without prejudice?
That is the purpose of having a Rule 11 evidentiary hearing.
At what point did the defense counsel say, based on this, Judge, we would ask you to find that he's not restorable and to dismiss the charges without prejudice?
At argument of each of the evidentiary hearings. That is why.
Do you have a citation to the record for those requests?
No, Your Honor, but there is no other reason to have a Rule 11 evidentiary hearing except to fight finding of competency and restorability.
But you could also say, gee, he's not restored yet, send him back for more restoration.
Well, 2 answers to that. First, that is not what happened in this case. And second, the court has its own duty to enforce the Constitution. And by sending Mr. Tepper back again and again into these conditions that destroyed his mind, that led him to live in his own urine.
Is that something that was ever raised at any of the proceedings, that it's the solitary confinement that's aggravating his condition, or was that raised at all, that this is the terms of the conditions of confinement? Was that raised at any of these proceedings?
2 answers to that. Yes, at the evidentiary hearing, in the Bishop statements, the attorneys told the court what his conditions of confinement were like. And second, the Rule 11 court...
But that's different than saying this is causing the problem. Was there a request to do something about that, I guess, is my question. To change the conditions of confinement, to say that this is an unacceptable way to treat someone in his condition.
The point of the Rule 11 hearings, the evidentiary hearings, the point of fighting it for the defense counsel was to...
I'm sorry, but this answer keeps recurring, and it's not an answer. We understand what Rule 11 hearings are for. We're concerned with what defense counsel did in this case to try to avert these consequences to his client. And so what would be more helpful is if you could point us to actual requests that the defense made that would have gotten him out of the condition he was in, rather than keep sending him back for more and more evaluation. The record reads to me as though the defense counsel was solely focused on the criminal proceedings and not very well focused on the amount of time that and the conditions that were being thrust upon Mr. Tepper.
At the 3rd hearing, defense counsel asked for Mr. Tepper to be moved to Desert Vista, which is a behavioral and mental health facility.
That's after 2 years had passed, right?
Yes.
That was the final hearing, and the judge said, no, he's restored. Let's set the trial.
That's true.
Before that, was there any request to not focus on just sending him back for more restoration?
Defense counsel never wanted more restoration. No defense lawyer in this county thinks that putting somebody in this jail will restore them, and no qualified mental health expert or anyone familiar, even glancingly with the law, would think that putting Mr. Tepper in jail could do anything other than destroy his mind.
But it's not just putting him in jail. There's proposed treatment that if the prisoner rejects that. But there was testimony from experts who were of the view that he was restorable. Was there not?
Yes, that is true. There were 13 evaluations in the record. 3 of those are from prior proceedings, but the state brought those up, so we'll consider them. Of those 13, 7 not competent, 6 competent.
Did any of the 13 say he's not restorable?
No.
Okay.
But that should have been really obvious at some point.
That's something else. That's different. But again, let me get back to an earlier question. What's the remedy? At this point, what's the remedy? And you said, well, we have all these cases, this is how horrible this is, and it's
Yes.
Kafkaesque. But do you have a case where the court said, given these facts at the end of a criminal trial on an appeal from the conviction, because of this situation, we're going to reverse the conviction?
Toscanino, Rochin, and In re Medley, which I mentioned from 1890, which is quoted and cited in the Madrid case from Northern California.
Toscanino, go ahead.
Yes, Toscanino from the Second Circuit, Rochin from the United States Supreme Court, and then In re Medley is discussed in Madrid, but I did not discuss it myself.
Okay, so in each of those cases, what you're saying is that on an appeal from the criminal conviction, where the person was held in conditions where they were trying to restore him to competency for longer than his sentence would have been, the court on appeal from the criminal conviction vacated that conviction.
Oh, no, absolutely not, and that's what's challenging about this. It did get to this point.
That was my question, though. My question was, what's the remedy on an appeal from the criminal conviction? And you said, well, reverse the conviction. I think that was your answer.
Absolutely.
And I'm asking if you have a case that they did that. Do you
The
have
closest
any
is Rochin.
Okay.
Toscanino, the person was brought over and convicted. He was brought from, I think, Uruguay, and by agents under command of federal prosecutors and law enforcement. He was tortured for 3 weeks and kept in confinement. And the Second Circuit in Toscanino said that this would, if sanctioned by the court, by upholding the conviction, would dirty the hands of the court, which is where we're at here. I wish more had happened, but that's where we're at.
And I'm trying to get to what actually happened. So when this case was initially charged, it was charged as a Class 5 felony.
Yes, Your Honor.
What was the maximum sentence?
Well, a year and a half is the presumptive. No aggravators were alleged.
So after a year and a half, did anyone bring up to the court that he had already accumulated enough time served to make the prosecution essentially moot?
I don't think mootness would have been a valid argument, but it wasn't earlier. It wasn't after a year and a half. It was after 2 years that the defense attorney
It would seem to me that it would be a very valid argument, and if somebody had brought a special action saying, why are we holding this man just to sentence him to 0 days, just to have a trial to sentence him to 0 days, that something has gone amok here, a remedy might have been available that would have been meaningful. It might not have been complete, but it could have avoided months and months of this process that Mr. Tepper went through.
Your Honor, this information was not hidden from anybody. The conditions that Mr. Tepper was in are known to everybody in the process, including the Superior Court.
Yeah, but nobody raised it. Nobody asked for relief at that time.
Aside from the Rule 11 hearings, which should have dismissed the case or put Mr. Tepper onto a non-criminal track, that is true. But
Wouldn't mootness also have to consider the fact that there would be a felony conviction that might be relevant for subsequent cases? So even though he had served that amount of time, I realize that he ultimately went to trial on a misdemeanor, but there are some collateral consequences to a felony conviction. So I don't know that you could just say that it's moot.
no, Your Honor, he was not competent. You couldn't try him.
Right, but just in terms of the question of once you've reached over a year and a half, are the proceedings moot? When
No.
when it's a pending felony charge.
No, he would need to be released. He could still be convicted.
And I recognize that formal mootness might not be the grounds for dismissal, but a request for relief from the situation that Mr. Tepper found himself in would have been timely and more efficacious had it been made 18 months in, wouldn't it?
Well, it depends what the result would have been. I don't know that a special action will result in any relief at an earlier point. And there's a reason in my briefing that I depended on the release hearing. And the state says, well, you're not challenging the Rule 11 holdings. And that's true, I'm not. And I don't think a special action at that point would have been successful. Probably the Rule 11 court's findings would have been held to be within the Rule 11 court's discretion. Now, as far as the conditions of confinement go.
But I'm puzzled, though, if there was no basis for a special action, what's the basis for relief once he's found to be competent and that trial is conducted?
Your Honor, the basis is a gross and outrageous violation of Mr. Tepper's rights.
So you're assuming, though, that he's incompetent, that counsel didn't raise at that point. I mean, and you're suggesting that it's the sua sponte responsibility of the court to do it is, I assume, then the argument?
At the release hearing, it's obvious. The record shouts, no, he was not competent. He could not understand the proceedings. He could not assist counsel. And then at the next... There is at least something in the record that suggested that it could have been an unwillingness to cooperate as opposed to incompetence. I agree that it certainly is a record from which you could find that he's incompetent based on what he was saying there, but there's certainly at least evidence and some discussion earlier on that there was perhaps some degree of malingering or just intransigence as opposed to incompetence. So it's hard for us on an abuse of discretion review to say that there's nothing in the record to support what the court did, if you put it in the context of everything that's happened prior to the hearing. Your Honor, I'd like to put in that context, and the proper standard is a bona fide doubt as to his competency. That is, if the court ignores a bona fide doubt, that's abuse.
I'm sorry. I didn't hear. You said...
The proper standard of review here is to ask whether the trial court had a bona fide or should have had a bona fide doubt as to Mr. Tepper's competency. And it's obvious that the court should have at the release hearing. Now let's talk about that. There is no malingering in this case. There is one site of malingering from a Rule 11 prior to this case. Prior to that case, two other contemporary evaluators also found Mr. Tepper staring catatonic in a room filled with dried vomit.
But malingering may not be the word I'm looking for, as opposed to an unwillingness to cooperate.
Your Honor, he was mentally ill. The context for his making of decisions was irrational. He cited biblical requirements for prosecution and said that the plea agreement was a lie. He wrote on his walls about his multiple resurrections. I don't think we can put the burden on Mr. Tepper to have cured himself.
I think we can, I don't know, we can. I think there's an undercurrent here that the system failed. That this could have been resolved earlier if defense counsel had asked the court to do something to stop this from going back to repeated restoration, and either held that he was restored or that he was not restorable and begun civil commitment at the request of one of the parties. We can all agree on that. But the question is, you're saying it was reversible error not to do that, and that's where I'm having a problem, finding that the trial judge committed reversible error by not sua sponte doing this when there's evidence saying he was restorable. I mean, if he had gone the other way and said there's evidence is restorable, but I don't believe that, he could have done that.
Two answers, Your Honor. First, the defense attorney, yes, I wish she'd done more. But she went through the Rule 11 process that's ordered by this court. And the Rule 11 judge kept ordering Mr. Tepper back into solitary confinement, which was outrageous.
She agreed at there was no request at the time the trial is set. There's no suggestion at that point. Defense counsel doesn't object to that. And wouldn't this be something that, to the extent there's a claim, could it be pursued in a Rule 32 to say if counsel had objected here? I mean, to the extent there is something, it seems more appropriate in that context than for us to say on direct appeal that there's a remedy.
Well, again, two answers. I guess I usually have two answers. First, what this court says will have a lot of impact on the Rule 32 because the defense attorney went through Rule 11. That's what she's supposed to do. Number two, most important, we're here. You have to decide what to do. The court can filthy and dirty its hands by upholding a conviction gained in violation, outrageous violation of Mr. Tepper's rights, and uphold it and affirm it and greenlight what happened. Or this court can follow Rochin, Toscanino, and the other cases I cited, where the court has held that what happened is so dirty that on appeal there is a remedy, and there is no other remedy besides dismissal with prejudice. That's where we're at. There's a lot I wish had happened, but now I am on appeal. I'm speaking for Mr. Tepper, and I'm asking this court, don't affirm this, because that's damaging to the system. Instead, provide guidance so that the next time this happens, the court understands and knows that it has a duty to enforce Mr. Tepper's constitutional rights, not to keep putting him into Rule 11, and that if he threw a rock through a window, we shouldn't torture him for it. And I'll reserve my 20 seconds, please.
Thank you.
Good afternoon. Assistant Attorney General Michael O'Toole on behalf of the state. Opposing counsel said there was one question in this case, and I agree, but he was asking the wrong question. The question is not whether this is kind of sympathetic situation for Mr. Tepper. The only question really is whether the trial court had a sua sponte order further competent proceedings. That was not required. And when we look at this, we look at the facts and the court's actions are here, non-action, in light most favorable to sustaining the court's proceeding without further proceedings. One of the fundamental things about opposing counsel's argument, problems with his argument, is that he's looking at everything in a light most favorable to reversing the trial court's action. We don't do that. He's just making bold statements about how absurd this was, and certainly this was an unfortunate situation, but there really was no legal error. What Judge Heggie had before him at the release hearing was essentially the same type of information he had before. Judge Heggie had seen this defendant on several occasions. He had seen him previously in a spit mask with SWAT team members alongside of him. He knew about his behavior. He knew about his outburst. There was some outbursts during the release hearing, but they were no different in
What if there'd been nothing before the release hearing? Based on the record at the release hearing, would that be sustainable?
Well, it's certainly concerning, I think, to a trial judge seeing a defendant being wheeled in a wheelchair with a spit mask and SWAT members. But I think at that point,
in absence of any coherent statements by Mr. Tepper at the release hearing.
I disagree, Your Honor. First of all, the hearing started out by defense counsel, Ms. Spears, indicating that she had spoken to Mr. Tepper on several occasions about having a bench trial or jury trial, and he indicated that he wanted a jury trial. And here we have an attorney who has thrice prior asked for competency proceedings, but now she's relating to the judge that she had this rational discussion with Mr. Tepper. The judge then confirms with Mr. Tepper that he understood what was going on and confirmed that he did in fact want a jury trial.
What was his response on that?
He said, yes, I do want a jury trial. And yes, I understand what's going on.
If the judge at the release hearing had held that I find that he is incompetent to stand trial, and I'm going to dismiss the case and not restorable, and based on his observations, and dismiss the case without prejudice, do you think, based on the record, that he would have abused his discretion?
I do, because as I think the trial court's minute entry ruling, Commissioner Brickner said that not one expert opined that he was not restorable.
He doesn't have to buy what every expert says. He can rely on his own observations.
That is true, but I still think it would be an abuse of discretion here based on the complete record and the findings of competency and the fact that no one had found that he was non-restorable.
But the problem here is that it's possible to comply with the rules and the law and still work an unjust process.
Yes, and one of the things I guess I learned during this looking at this case is that, in fact, you can detain someone just for the competency proceedings alone, even I think if it's a misdemeanor, which seems drastic, but in fact I think that's the rule. We want to make sure people are competent. This is a kind of a rare case. I haven't seen one like it before. I'm not aware of one in Arizona or anywhere else quite to this effect. Usually when it's a lower level offense, here a class 5 felony initially for most of the proceedings. It is unfortunate, but I think here there was no legal error.
Was there in your view, is there some remedy regarding the solitary confinement? What could have been done earlier, if anything?
Well, that's really a call for the sheriff's department. I mean, they have to protect their staff. They have to protect other inmates. They have to protect the defendant himself. He had a history of assault.
But if somebody wants to challenge that, what's the forum if defense counsel wants to?
That would be a civil case, and I wouldn't be here defending it. It would be people from the county attorney's office, and we basically.
Although Commissioner Vatz had a case several years ago in which they dismissed the charges. He dismissed them with prejudice because the person was not being held in solitary, but was released to the general jail population, and the evidence was that he actually regressed. So I think there is there must be some kind of remedy where you can hold hearings about whether the person being held is actually being restored. There are efforts being made to restore. And in Commissioner Vatz's proceeding, they had hearings, and the sheriff's office said, we don't have the money to do that, so we're just releasing him to the general population. So there's got to be some procedure.
Well, certainly if defense counsel would have thought this was the issue, that his mental state was dependent on his living situation, then that could have been raised as an issue that the parties could have litigated below. But frankly, not one expert basically commented that this was something that was affecting his mental status, and I don't see that it is, other than opposing counsel's blanket statement that was the cause for the problem. I don't have a lot more, but I would like to point out that every single case opposing counsel cited for dismissal with prejudice involves a situation with outrageous prosecution misconduct.
I'm sorry, without?
Every case that opposing counsel has cited that he says supports a dismissal with prejudice is based on some type of misconduct by the state. Here, there is no misconduct by the state at all. He basically disagrees with proceedings below and the trial court's decisions and perhaps defense counsel's attempt to litigate the case.
So you're saying in the Tuscaniano case and the Roshan case that it wasn't vacating the reversal based on being held beyond the terms of the time that he could have served, but other prosecutorial misconduct, other state misconduct?
Yeah,
right?
the Roken case involved basically, intrusion into the body without a warrant, and the other case involved forcibly bringing someone to the United States against his will. I mean, it's just completely an opposite.
Right.
You would agree, though, that the system could be improved here to prevent these sorts of results?
Yeah, this is unfortunate. I haven't seen it before, and I'm not sure we have to retool the whole system because of this case. I'm not sure if defense counsel kind of erred or if she was just being conscientious and doing what she thought was right at the time. So I don't think we should be looking at retooling the whole system based on this one case.
I'm not suggesting that we would do that, but there is a wrong here. I don't sense that you disagree with that.
I don't.
The question is whether there's a remedy. And I suppose my invitation to you before you sit down is to talk to us about the incarceration after trial, before sentencing, which seemed to add insult to injury.
A little bit, but it was 26 days, and that was based on
26 days in jail just to have a hearing to tell them you're letting them go seems a bit much.
It does, and I know opposing counsel suggests that possibly he could have been sentenced in absentia, which I personally would not have a problem with, but I think if that would have happened, then at that point his appellate attorney would have raised that issue and said he had a right to be there at sentencing. So,
what's the quickest it would have happened, assuming he had been cooperative? How much time would he have spent in custody being arrested?
I really don't practice in the trial court, so I don't know how quickly you can get these things done. I don't know why his attorney didn't really make a full court press to get this done like tomorrow. I don't know why that is.
There was no request to accelerate it?
No. I mean, possibly there's some kind of ineffective or civil claim against his attorney for not doing that. But basically, I think maybe to some extent the attorney was at fault for not getting that done. But
and that may be. Do you know if there was a release hearing when he was picked up on the bench warrant?
I don't know, but I would assume that he had so many failures to appear in the past that they wouldn't let him on OR at that point. So.
All right.
Okay. Thank you.
Thank you.
18 seconds. I'll simply note that the sentencing was continued 3 times by the court for Mr. Tepper's intransigence and outbursts, and actually I think one of those times he refused to be transported, and that would explain the long delay.
So it would have been a matter of a week, is that?
I believe it would have been something like a matter of a week rather than the 26 days. But my position is they could have done it at the end of his conviction.
Is there a case, and maybe it's in your brief, that says you can sentence someone in absentia?
The cases are consistent in saying you can't accept for exceptional circumstances. And if this wasn't an exceptional circumstance, I don't know what would be.
But would you do that without a request? Would there be exceptional circumstances? I'm sure there could be exceptional circumstances, but would that be something a court would do without an explanation, a request from defense counsel to say there are exceptional circumstances, don't sentence my client in absentia? It seems like that would create an issue on appeal if counsel had not made that request. How would the court know that that's? Why would a court proceed on its own in that circumstance?
The court has the information that Mr. Tepper had already served 4 times his maximum sentence.
And there was no other sentencing provision possible at that point, right?
No, misdemeanor is maximum 6 months.
Okay. So, I have to ask if you know why defense counsel didn't just say, let's not hold this over for sentencing. There's no sentence that can be imposed that's going to be prejudicial to my client. What's going to be prejudicial is picking him up and holding him for a month to tell him that there's no sentence.
Yes, sir.
That motion, had it been made, might have been successful.
Absolutely, Your Honor, and a lot of the defense attorney should have done more, but I think guidance to the courts to not allow this as well would be helpful.
It seems like asking a lot from the court who may not be going through at that stage, knowing exactly how long the person has been in custody, what the maximum sentence is. It seems like it's kind of a perfunctory, I'm going to set a sentencing date, and without somebody triggering, it seems like it's asking a lot for in every case for the court to go through and say, if we don't do this within the next 2 days, it will be beyond the maximum amount of time that could be served. So
Well, the court knew that because that was the argument at the release hearing. But also, I mean, there's a couple of things that the trial court gets from the staff and the computer and the at a sentencing, and those are 2 things that the court will always have.
So it sounds to me that what you're telling us is that even if we concluded we could not reverse the conviction or would not reverse the conviction, to at least say something, to give some guidance to trial judges to try to avoid this kind of situation again.
Yes.
Is that fair? Okay.
All right.
Thank you
very much. Thanks to both counsel for their arguments. The matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.